One of the issues that comes up most frequently is whether or not something that you call commerce can ever be protected by the Constitution as a private act. And the answer to that question is yes, it can and it is. The purchase of contraceptives is guaranteed as a right to privacy, but that's commerce. That's paying money for a contraceptive. A woman's right to terminate her pregnancy has been emphasized over and over again by both the U.S. Supreme Court and the California Supreme Court as a privacy right of a woman. And so it is simply not true that commerce and privacy are incompatible.
Because people argue a lot that in terms of, when prostitution, that it's not private. That is an argument that, when people argue against the case, saying the case has no merit, that is something we hear commonly,
Yes, it is. And it's an instinctive and quick response. And unfortunately, my feeling is that a lot of judges that may be their initial thought. But we have to take time and be careful and explain that's simply not the case, that there is a great deal of buying and selling of services that are private. Even not in the context of, say, contraceptives and abortion. Even your banking information, that's private. If you want to get someone's banking information, you have to get a court order to do that because it is private. Well, what could be more commercial than your relationship with your bank? Now, if you have a man and a woman in the woman's apartment and they are having sex, no one denies that that is private. As a matter of fact, the Supreme Court in Lawrence says our private conduct, our sexual conduct is the most private action. Well, if right before they have sex they hand over cash, that by itself should never destroy the privacy of the act. Even if you believe that's wrong, and even if you believe that's harmful, it's still a private act, and it's just as private as the sexual act. There are cases that make it clear that when the state forbids you to pay for a service, even though it does not forbid the service, that nevertheless is a burden on privacy if that service itself is private. For example, the Fifth Circuit in Reliable Consultants case, the Fifth Circuit ruled that a Texas statute forbidding the sale of sexual aids, that is dildos, was unconstitutional because it is private to use them, and even though the statute did not ban the private use of sexual aids, nevertheless it said you couldn't buy them, and by saying that you could not buy them, they were burdening that privacy. Likewise, the U.S. Supreme Court in Kerry also guaranteed that a state cannot burden a person's right to purchase contraceptives. They cannot even limit your right to purchase contraceptives. A statute had tried to limit a purchase to licensed pharmacists. And the court said you can't do that because you are limiting this private behavior, and it is to no avail to come back and argue, well, we're not prohibiting it, we're just saying you can't pay for it. And the court said, no, that is not a good argument. You are burdening that right to privacy. There is another way of thinking about commerce where the state has taken in this case, where they will say, we're only forbidding the payment of money. We're not really banning or prescribing any relationship or any unique interaction at all. Implicitly, whatever you do in the context of prostitution, you can do elsewhere without paying for it. And that is simply wrong. I mean, people who know what they're doing, who do research on this matter, they understand and they will tell you that there is a great deal of interaction between prostitutes and customers that is sometimes long-lasting, that is very often has an emotional context to it. There are postings that men have made discussing call girls that have been reviewed with academic rigor, and they discovered that men talk about call girls the way they talk about girlfriends and non-commercial relationships. And there's an emotional component, and there's worry, and there's stress, and there are decisions about how long to maintain a relationship, and the relationship is the right word. With a call girl. Studies have been made in Los Angeles County of call girls, and almost half of the clients of these call girls who were studied were regular customers, and almost half of the regular customers had been seeing the same call girl for over a year. There are many instances that demonstrate that the state has no business telling, for example, a woman who is selling sex, telling her what relationships she does and does not have in her life. That is the epitome of arrogance. And if she has men who come to see her, month after month, year after year, that is her business, and those are relationships. Maggie McNeil is a former call girl and former madam. She writes in her blog, The Honest Courtesan, about her relationship. She married one of her clients. She provided sexual services for money to severely disabled men. It is highly improbable that those men had access to normal sexual lives. She was one of the few people who provided sex to them. It is absurd to claim that if you are banning that relationship, you are not banning something unique. It was clearly unique. Mm-hmm. So unique interaction in a unique relationship with that woman, and the fact that you're paying her money does not make it anything less.